All right. Well, good morning, everyone. My name is Sean McCoy. The name of my company is Federal Employee Benefits Advocates. We're an educational company. We're based in Parker, Colorado, and I've been doing benefit briefings now with federal employees for about 10 years. And during that period of time, one of the issues that came up consistently as I was doing the briefings was questions that centered around divorce. And the more and more I looked into it, the more and more I realized that I needed to provide some educational information available to federal employees so that they can better understand the decisions and the choices that they need to make when they are faced with a divorce situation. Today, we're able to provide this information to the USDA through courtesy of Linda Duncan. She has set this up. And so we'll spend about 50 minutes going through this presentation. We'll have time available at the conclusion of each section for questions. There'll also be a recorded version of this available that will be distributed to all the people that signed up for the program. So we'll go ahead and get started. So the things that we're going to cover today are the benefits that can be affected by court orders, why federal employees are different because of the different types of court order and the benefits that can be dictated. We'll go through how the thrift savings plan is affected. We'll talk about the federal employee health benefits. We'll also cover briefly FEGLI, and then we'll end the day with the roles and responsibilities of each party. So the first thing is what benefits can be affected by a court order. The first thing that can happen is they can divide the CSRS or the FERS annuity, a refund of the FERS annuity employment contributions. They can also provide a survivor annuity upon the death of the employee. They can permit a former spouse to continue under the Federal Employee Health Insurance Benefits Program. They can also require an employee to cover his or her children under the FEHB, and they can require an employee or retiree to assign his or hers federal employee group life insurance, the FEGLI, to a former spouse and or children. Now, the court order will not bind the parties, not OPM or the agency in the case of the FEGLI. It also can require an employee to name his or former spouse or children as beneficiaries under the FEGLI. It also can require that retirement benefits be garnished for alimony, child support, or for cases involving child abuse. Now, the benefits that cannot be affected by court orders, they cannot make a former spouse eligible for the Federal Employee Dental and Vision Program, the FEDVIP. They cannot make an agency or retirement system enroll an employee annuitant in the FEDVIP for the children, or make a former spouse qualified to be eligible to enroll in the federal long-term care insurance if they are not enrolled at the time prior to the divorce. So why are federal employees different? Well, federal employees are different because in the private sector, the Employee Retirement Security Act of 1974, otherwise known as ERISA, applies to all private sector employee benefits. The term employee benefit plans is an employee welfare benefit plan, that an employee pension plan, or defined benefit, defined contribution plan, or both. Orders that divide ERISA-based plans are commonly referred to as what's known as a QDRO, or sometimes referred to as a quadro, but that stands for a qualified domestic relations order. Now, unlike the private sector, civil service retirement system and federal employee retirement system, FERS, are governed by a separate set of federal laws and statutes and regulations. CSRS and FERS are not governed by ERISA. So an order dividing a CSRS or FERS due to a divorce is what's called a court order acceptable for processing, or the acronym for that is a COAP. So a court order can be issued by any state, territory, Indian court in conjunction with a divorce, annulment, or separation of a federal employee. The court order, the COAP, must meet the regulatory requirements to effect an employee annuity, a refund of employee contributions, and a survivor annuity awarded to a former spouse. Now, to effect an employee annuity or refund, refund of retirement contributions, the court order must specify a CSRS or FERS benefit, expressly state that the former spouse is entitled to a portion of the employee annuity or refund, expressly direct OPM to pay the former spouse directly, or be silent on who the payer is. So as far as the court order acceptable for processing, it must provide sufficient information for OPM to compute the amount that the former spouse's share of the employee's annuity or refund. In the case of an apportionment of an employee annuity, otherwise known as an apportionment, it must specify the type of annuity for the application of the formula, percentage, or fraction. So what happens in this case, this is a situation where the employee retires and begins drawing their annuity. And so this is what's known as an apportionment. So there are two different terms to look at. One is apportionment, the other would be through the survivor benefits. Now, it must distinguish between a net annuity, a gross annuity, or a self-only annuity. So how are the benefits payments made? Now, a court order can affect three types of benefits paid by OPM, and OPM treats each of these three independently. The first would be the employee annuity, which would be while the employee is alive and receiving the annuity. If the employee does not receive retirement, it could affect the refunds of any of the employee contributions. And then after the employee has passed away, then it would also address survivor benefits. So OPM considers each of these awards separate and independent of the other two. So the court order acceptable for processing must address each of these three items. So it can apportion or divide a CSRS or FERS benefit in connection with divorce, legal separation, or annulment. It must expressly direct OPM to pay a portion of the monthly CSRS or FERS benefits. Now, when it states the former spouse share as either a fixed dollar amount, a percentage or fraction of the annuity, or a formula. Now, the formula that's most commonly applied if a formula is used is the number of years employed the number of years married divided by the number of years employed. As an example, if an employee was married 15 of a 30-year career, then that employee, the spousal percentage would be expressed as 50% of the benefit that the survivor benefit would be eligible for. Now, payment under a court order may not exceed the net annuity. Now, the apportionment, that is the part that the former spouse would receive. That apportionment ends when the retiree's death. So the apportionment ends. Now, the survivor benefits would be payable upon the death of the retiree, and this must be elected by the retiree or the court order. Now, refunds can also be provided that all or part of a refund to retirement contributions be made to the former spouse. It can also block a refund. The court can also block payment of a refund, but only if the order directs OPM not to pay the refund and also grants a survivor or apportionment of the retirement annuity to the legally separated or former spouse. Now, before we get into this next slide, I want to go back and just review slightly, because when these orders are put together, one of the things that has come up in the last year or so has to do with the FERS receiving the special retirement supplement. So unless the order expressly directs how the special retirement supplement will be handled as far as payouts, then the OPM will in fact give that portion out based on how they're going to be distributing the apportionment or the survivor benefit. So that's one of the things that is important. It's not in the slide, but it is something that has come up recently to be an issue. And so that is an item that the employee would want to address in the COAP. Now, the maximum benefit for a CSRS for current and former spouse's annuity equals 55%. So that is another issue that must be addressed in the COAP, is the fact that it will allow the sharing of the annuity. Because in some cases, I have reviewed documents where it does not allow a future spouse to receive a portion of the benefit. Now, the FERS maximum is 50%. So again, a court order awarding a survivor annuity to a former spouse reduces or eliminates the survivor annuity that can be paid to a current spouse of the annuitant at the time of death. Now, the former spouse annuitant, either under the FERS or the SERS, can be split on a pro rata basis. So with SERS, a survivor benefit annuity is payable. With FERS, a survivor annuity is only payable if they have 10 years of creditable service. Now, the exception to that would be if the individual was age 62 and they had 5 or more years of service. However, if an employee dies in service with less than 10 years, what is awarded is what's called the basic death benefit, which is equal to 50% of the employee's final salary or high 3 average, whichever is greater, plus a lump sum this year currently of $33,072.02. Now, if that is the case, then that means that there is no additional survivor benefit, and that would create issues for the continuation of health insurance for a current spouse, not the former spouse. We'll address that here in just a moment. Now, the cost can be apportioned between the employee and the former spouse. If the COAP does not address it, they actually will deduct it from the employee's annuity. So it should direct them how this cost will be reduced. It should also address at what rate that they're basing this on. Is it based upon the employee's salary at the time of divorce, or is it based on the employee's salary at the retirement date? In most cases, the preferred method is to do it at the time of the divorce. Thus, any additional increases in the salary would not be subject to that reduction of the benefit. Now, a court order cannot order a former spouse unless the marriage lasts at least 9 months. A former spouse annuity ends if the former spouse remarries prior to 55 unless the employee and former spouse were married for 30 years. This is another factor that is not conveyed oftentimes to the former spouse. The other thing is that federal law supersedes any state law with respect to the payout of the annuity. So oftentimes people will get remarried prior to 55 and they will claim that they are entitled to a portion of the annuity. However, that tie is severed if they do remarry prior to age 55. Now, if an employee dies, the court order surviving benefit is payable to the former spouse if the employee completed at least 18 months of service while under the CSRS or the FERS coverage. Now, if the employee has been divorced, certified copies of the divorce decree supporting the documents must be accompanied for the survivor application. Now, separated former employees, if they die under the CSRS program prior to receiving a benefit, then there is no survivor annuity. So, for example, if a former employee covered under the Civil Service Retirement System left under a deferred retirement, there would be no payout available to the former spouse. Now, under the FERS, in certain limited conditions, a survivor annuity for a former spouse may be payable if the separated former spouse dies before retirement. Now, that would generally occur if the employee had applied for a postponed annuity. Other than that, if it's a deferred annuity, just like the CSRS, they would not be entitled to a portion of the annuity. Now, annuity employees are subject to the COAP only if all the conditions for the payment of the employee annuity to the former employee have been met, including but not limited to separation from the federal government covered by the FERS or the CSRS retirement system, application for payment of the annuity by the former employee or the former employee's immediate entitlement to an employee annuity. So the bottom line is that a former spouse cannot apply for a benefit under the terms of the COAP unless the employee retires and applies for the benefit or they die. So that is one of the factors. Now, in the private sector, it's different. In the private sector, whenever that employee becomes eligible, regardless of whether or not they begin to draw, they can, in fact, start drawing, but under federal law, they cannot. Now, unless expressly stated, the COAP terminates when the former spouse dies. And what happens in that case is the portion that's being reduced then reverts to the employee. Now, again, OPM will have to be notified. This would not happen automatically because OPM would have no knowledge of it unless the employee provides that information that the former spouse has passed away. Now, refunds can also be applied to former spouses. The court order that awards a former spouse annuity based on the service of an employee who is not eligible to retire can include additional instructions to tell OPM what to do if the employee requests a refund of the employee contributions prior to becoming eligible. A court order may order a former spouse a portion of the refund of the employee's contribution or bar payments of the refund of the employee's contributions. Now, the other thing that it may also want to include would be a clause related to sick leave, whether or not the former spouse is entitled to any sick leave, excuse me, I apologize, not sick leave, annual leave that would be paid out. So the cost of a former spouse survivor annuity, basically it lowers the gross annuity available. The cost associated with providing the former spouse must be paid by an annuity reduction. If a former spouse is awarded a portion of the employee annuity sufficient to pay the cost associated with providing the survivor annuity, the former spouse's share may be reduced to pay the cost. So an employee who is in good health can make an insurable election to provide a current spouse with a survivor benefit. See, what happens because of the order of precedence, a former spouse takes precedence over the current spouse. Now, only if the current spouse has consented to an election not to provide a regular current spouse survivor annuity, and this would occur through the selection of the SF 2801, the -2, or for the FERS applying, it's a 3107-2. So again, that goes under the insurable interest clause to provide for a current spouse. So on the applications, both of them would be the box 4 choice, and then the former spouse would be elected to be shared under box number 5. Now, the cost in order to share is based upon the insurable interest clause. So the insurable interest cost basically says that based upon the difference in the age, then the cost to provide that benefit increases in 5-year bands. So if someone were providing a current spousal benefit to a current spouse that was older or the same age or younger, the insurable interest clause says that it's a 10% reduction. And then it increases in 5-year increments at 5% per year. So the next slide is an example of, say, a FERS that was sharing the cost with a current spouse. Their basic annuity calculated at $20,000 using the appropriate FERS annuity formula. The first spouse, because they take precedent over the current spouse, would have a reduction of 10%, in this case, a $2,000 reduction. The reduction for a current spouse in this case is 20%. Now that 20% assumes that that person is 10 but less than 15 years younger. So the cost associated with providing both a current and a former spousal benefit in this case is approximately a 30% reduction. So what it means is that oftentimes a federal employee who is getting a divorce, providing a survivor annuity may not necessarily be the right choice. That, as you can see, can be very costly, particularly if the individual decides they're going to remarry and have both a current and a former spouse in order to provide a benefit for. So before we go on, Nick, let's go ahead and open it up to see if anyone has any questions on what we've covered so far.
Excellent. No chat thus far, and let's experiment. Sometimes this is jarring when I unmute everybody, so I apologize.
All right.
Yeah.
Okay, so we've unmuted everyone. If you don't mind, if you do have a question, if you will speak up. Otherwise, if you'll mute your phones, we're getting quite a bit of background noise.
I think we're good.
Yep, I think so too. So we'll go ahead and move forward.
A minute as I get everybody muted. All right, there we go.
All right, so the next section that we're going to cover has to do with the thrift savings plan. Remember, the thrift savings plan, unlike the pension, which is a defined benefit plan, this is a defined contribution program. And so as a result, some of the requirements in order to access those funds are different than what they would be for the regular CSRS or FERS pension. Sorry about that. For some reason, my mouse is not performing well. Now, the TSP can be divided by a valid court order. Now, the TSP will provide a spouse and attorney upon written request information about the TSP account, such as the participant's or beneficiary participant's account balance, the participant's outstanding loan balance, if any, and any annual or quarterly statements. Now, what TSP will not provide is personal information, such as the participant's address, their date of birth, as well as their social security number. Now, request for the account information must be in writing, and it should be directed to the TSP legal processing unit. What it should provide is the participant's or beneficiary participant's name and TSP account number or social security number. Now, the beneficiary participant's account, that would occur if the federal employee had an account that was provided through the death of a former spouse. They identify the individual requesting the information to describe his or her relationship to the participant, describe why the information is needed, and state the purpose for why the information is being requested. So the participants or participant beneficiary, his or her attorney may obtain account balance, the TSP transaction history by submitting a written request. Now, a subpoena is not required by OPM in order to provide that information. So a TSP can be divided by a court decree, divorce, annulment, or legal separation, a court order such as a court order approved property settlement agreement incident to such a decree, and a court order may be issued at any stage of the divorce, annulment, or legal separation. Now, TSP calls that document a retirement benefits court order. So that differs from the court order acceptable for processing that OPM requires. So some of the basic requirements for the TSP, there's 4 basic requirements. The order has to be issued by a state, territory, or an Indian court. It must specifically name the plan, the thrift savings plans. So ambiguous terms such as all retirement benefits, government benefits, thrift savings, or thrift savings account are not adequate. If the court requires a payment to the TSP account, it must clearly describe the pay's entitlement, and it can only award a specific dollar amount or fraction or percentage of the participant's account on a specific past or current date. So those are the 4 basic requirements that the order must require. So the payments will be made pro rata if the federal employee has both the traditional and the Roth TSP from which they have investments. So the balance is based on each fund on the date the payment is made, and it will be from all contributing sources. So that would include employee contributions, the employing agency, or any service contributions. Now, the TSP will pay the money out one of 2 ways: a U.S. Treasury check paid directly to the payee, or what's more commonly used is an electronic funds transfer to the payee's financial institution. Now, as far as the tax treatment made under a court order or legal process depends on the type of money that was contributed. A TSP account can consist of either the traditional TSP or the Roth TSP, or maybe both, the Roth and the traditional. Now, if the employee, if the former spouse receives the benefit and takes constructive receipt of it, then in that case, there's a potential that there could be taxation due intended or also ordinary income tax plus a 10% penalty. In the case of the Roth, if the money has been in the account for 5 years or age 59 and a half, whichever is longer, then the money that may be withdrawn from that account would come out tax-free. So there's some additional information that must be considered. And again, this material is not designed to replace the advice of a tax professional as it relates to distributions under the TSP. So as you can tell, the TSP is a little less complicated to get the money out, but there are some rules that have to be addressed regarding the potential taxation of the benefits if it's prior to age 59 and a half. We'll back up for just 1 second. So what we're referring to is the Civil Service Retirement Equity Act of '84. Again, it allows certain spouses of federal employees, former employees, and annuitants to qualify for health insurance under the FEHB. Now, in order to be eligible for the benefits, there's one of 4 requirements that they must meet. He or she was covered as a family member under the FEHB enrollment at least 1 day during the 18 months prior to the end of the marriage. He or she is entitled to receive a portion of the annuity after the employee retires or survivor annuity at the time the employee retires or dies. He or she submits a written notice within 60 days after the divorce to the agency employing office where the federal employee worked at the time of the divorce, stating that he or she wants to continue the FEHB under the spousal equity provisions law. Now, if the divorce occurred after retirement, the employing office is now the retirement system. So what happens in this particular case is if the employee is still working, they will deal with the agency. If the employee is retired, then they will have to address these issues with OPM. Also, the other contingent factor is if that individual does not remarry prior to age 55 to keep the health insurance eligibility. So a former spouse who qualifies must enroll in his or her own right and must pay both the employer and the government share of the premium. So what that means is they are paying 100% of the cost. Now, coverage is prospective from the first day of the pay period after the employing office receives all properly completed qualifying documents. Now, what will happen in most cases to avoid a break in coverage, the former spouse may want to enroll for the temporary continuation of coverage under the TCC provision. So another thing that can occur is if a former spouse is not eligible to retain the coverage under the employee's family enrollment, they are no longer an eligible family member. A former spouse who does not qualify for one of those 4 conditions under the FEHB may apply for the temporary continuous coverage. So that would be that they would pay the employer the employee cost plus a 2% administration fee, and they would be limited to a 36-month period for which they could stay on the benefit, and then after that, they could convert to an individual policy with guaranteed insurability. So again, the cost to share is going to be the employer, the employee plus the 2%, and it can continue for up to 36 months. Now, COAP, granting the former spouse portions of the retirement annuity, provides the former spouse with a monthly payment after the employee retires and continues FEHB coverage until the employee dies. Now, a COAP providing a survivor benefit provides the former spouse with continuation FEHB coverage until the former spouse dies, but the annuity does not begin until the employee dies or retires. So there's 2 different ways. Again, this goes back to the apportionment while the employee is still working, and that means that the former spouse is receiving a benefit. The survivor benefit comes into play when that employee dies and they're retired, and in that case, the COAP would also want to address that. So that's another issue oftentimes that is overlooked or not properly addressed, is that the survivor benefit is available while they're alive and then also would continue upon the death of the federal employee. So a COAP provision that provides both a portion of the retirement annuity through the apportionment and a survivor benefit ensures that the annuity payment from the date of retirement or death will continue the FEHB coverage until the former spouse dies. Now, a COAP can also direct as to whether or not the employee is responsible for that former spouse's health insurance costs. So in that case, that would be very expensive to do because at the 102% rate, that does make it quite expensive. So what we're going to do now, again, as we've done before, Nick, is open it up to see if there's any additional questions that might have incurred as we went through the FEHB section. So if you want to open it up, and then we'll go into the life insurance section. Nick, did you want to open it up to the group?
Oh, I wasn't on mute. I apologize. So Sean, Linda's asking at the end, and maybe this shouldn't go at the end, but can you go over the high 3 calculation for SERS and birth annuity? Is often left blank.
Yes, I can. Yes.
Okay.
Yes, I can. I'll go through over those calculations. I didn't include some of the information just because of the limited time frame that we had for this. This briefing is actually designed to be delivered in either a 4-hour or a 2.5-hour setting, but for the purposes of today, we limited it to an hour. So there were some things that I just could not get into the program, but I'll certainly address that at the end. So if there's no other questions, what we'll do at this point is we'll go ahead and continue on.
Perfect.
Okay. All right. So the next section we're going to cover is the federal employee group life insurance, or the FEGLI. So with the FEGLI, there are several different types of coverages that are available for the federal employee. So those coverages would be the basic benefit. If the employee is under age 45, it's the extra protection benefit. The basic benefit is their salary rounded to the next $1,000 plus $2,000. The extra protection benefit is equal to the basic. However, beginning at age 35, it starts to stair step down 10% per year until at age 45, the extra protection benefit goes away. They're talking about the extra protection benefit. It goes away at 45. Option A is a flat $10,000 with a $10,000 accidental death and dismemberment. Option B is a salary multiple. It's the employee's salary rounded to the next $1,000, and then a salary multiple of up to 5 units, five times the salary. Option C is sold in units. 1 unit is $5,000 for a spouse, and the maximum is $25,000 for a spouse. 5 units for a child would be at $2,500 a unit, would be a total of $12,500. Now, the accidental death and dismemberment benefits are only included in the basic and the option A coverage. So the FEGLI can be assigned as a result of the court order. They can make an irrevocable assignment, which means that once that assignment has been made, they cannot change that. Now, it could transfer it to his or his coverage to another person or to a trust. Now, the individual who assigns their FEGLI ownership will continue to be insured under the FEGLI program. This irrevocable transfers the assignee many of the basic rights, responsibilities of their basic, standard, optional, and additional optional insurance. So an assignment automatically cancels a prior beneficiary designation. So it would be important for the person to whom it was assigned to select who that beneficiary would be. Now, the assignments or insurance are generally made to comply with requirements under a divorce court order. Under FEGLI law, an insured person may change his or her designation of a beneficiary at any time. This is even true if the court order directs otherwise, because federal law preempts state and other court-based state laws. So assigning FEGLI to a former spouse means that the FEGLI benefits are awarded to the former spouse in a divorce. The employee is not able to circumvent the award by changing the designated beneficiary or canceling the coverage at a later time. So it locks them into doing that. Now, the law does not require OPM to force or comply the provisions of the court order directing OPM or federal employee to assign the coverage. So it's up to the participant to make that happen, as well as the former spouse. It is a responsibility of the court order designee to ensure that this order is enforced. So they must take control, and they must make sure that this process is completed. So once the insurance is assigned, the employee may designate beneficiaries, convert the insurance to an individual policy if the insured's eligibility for the group insurance ceases, or cancel the insurance or reduce the coverage amount. Now, the federal employee or former employee retains the right to elect new coverage, though all new insurance, excluding family optional insurance, is subject to the existing assignment. So if they did want to make changes to it to increase it, then they would have to follow the court order of that assignment. Now, the assigner also retains the right to decide at the time of retirement or receipt of a workers' compensation to maintain more than the minimum of his or her basic life package. The assigner also continues to be responsible for the premiums, and the premiums will be withheld from the assigner's pay, their annuity, or any type of compensation. So OPM does enforce the payment of it so that the individual who had made the assignment, the assigner, cannot just simply go in and cancel the coverage that once it's been assigned. So the final section that we're going to cover, and then we'll open it up, I'll go through a brief conversation about the high three average, are the roles and responsibilities of each group. Now, the employing agency is the proper source for the employee to get information from, because the agency retains the electronic official personnel file. OPM does not receive those records until the employee separates from employment. So the employing agency would be the ones responsible for the enrollments for the former spouses and receives premiums, as well as makes any assignment of the life insurance of the employee that they may make. Now remember, for the health insurance, the former spouse pays the full cost plus the government rate. Now, the agency may provide in response to a subpoena signed by a judge or release a signed statement from the employee for the retirement system coverage to talk about the amount of money that's withheld by the agency to the employee's credit in the retirement fund and an annuity estimated using the date to service. Now, agencies can only prepare estimates on what the employee has already earned. The agency cannot provide estimates that involve speculation or in any way attempt to advise an employee, spouse, or attorney about how to draft the court order. Now, as far as OPM's roles, their role is strictly ministerial. So OPM makes a determination regarding the acceptability of the court order and the rights and the benefits. Now, this is an important part that's often not taken into effect by the former spouse or by the employee. That COAP must be submitted and approved by OPM prior to the divorce. If an employee waits until the time of retirement and attempts to submit the information, it will cause a delay. And as most of you on this call know, that is already an elongated process, so it's just going to further exacerbate it. Now, OPM informs the former spouse that the court order is acceptable, the date of the spousal benefit to begin to accrue, if known, and the monthly benefit and formula used to compute it. If the individual, he or she, disagrees with OPM's assessment, then they must also get an additional clarifying court order, must be, again, submitted to OPM and reviewed and approved by OPM. Now, as far as the effective parties, they must apply for the benefits along with a certified copy of the divorce decree, legal separation, or other court and other supporting documents to OPM. And as an example, property settlements, marital separation agreements, referenced and incorporated into final decrees. They also must keep OPM advised of current mailing addresses and living statuses of both the former spouse who is claiming the benefit and the federal employee whose benefits are being affected. So also, if there's any changes to circumstances that could affect benefits, submit all disputes with the employee and retiree to the appropriate state court for resolution. The former spouse should file the information as soon as possible. A former spouse must apply in writing to be eligible for a court-ordered apportionment of the employee's annuity. There is no special forms that are required. If the former spouse is incompetent, a representative may apply on their behalf. So for information about court order benefits, this is how you would contact OPM. There's a phone number, 888-767-6738, or by email, or there's the Office of Personnel Management in Washington, D.C. So what I'm going to do now is I'm just going to take just a few moments to talk about how the high three is determined. Now, the high three average consists of the highest 36 consecutive months, no matter when it occurs in an employee's career. So it includes base and locality. Now, there's some exceptions that are not included. Those would be things such as overtime pay, holiday pay, travel pay outside the regular tour of duty. Now, if an individual gets a specialty pay, that will count. But the exception to this would be individuals who would be classified under law enforcement, air traffic controller, those and firefighters. Those special provisions, overtime does count, or unavailable, or LEAP, which is law enforcement availability pay, or uncontrolled overtime pay. So those would be the exceptions to the high 3 average. And again, they look at the highest 36 consecutive months, no matter when it occurs during the career of the employee. So what I think we'll do now, Nick, is we'll go ahead and open it up for questions and to see if there's any additional information that people may have about the program before we close out.
All right, sounds good. Seems like unmuting, if folks want to type in the questions, that's great. I will try to unmute everybody, but we do get some noise. I'm doing it individually. Sean, we have about 2/3 of the people unmuted.
Okay. All right. Well, it sounds like we don't have any questions, Nick, so let's go ahead and mute them. The final thing is a little bit about my company, Federal Employee Benefits Advocates. We do federal employee briefings for federal agencies all over the country. We've been doing it now. I've been working with federal employees now for about 10 years. And during that period of time, I've probably spoken to somewhere in the neighborhood of about 17,000 federal employees. We are considered a government contractor. We do have the CAGE code, and we do have information available about the services that we provide. So we do provide information on full day, half day briefings for both CSRS and as well as the FERS. We also have a financial literacy program that we can provide. Now, these programs do comply with the requirement that OPM says that the agencies are required for coming up with providing financial literacy at the early, mid, and late career. So these programs are in compliance with that program. So again, I'd like to thank each and every one of you for participating today. I'd also like to thank Linda Duncan for taking the time and the effort to put this together for the organization. If you do have additional questions after the conclusion of this, you can certainly contact us at info@febadvocates.com, or you can visit our website at www.febadvocates.com. So with that, we'll conclude today's session. Thank you very much for participating. And again, have a good rest of the week and a great Labor Day weekend. Thanks, everyone.
Thanks, Sean. Have a good day.